Judge, it looks like we have about everyone. I'm just looking for, there's Ms. Monens, there's Ms. Harker,
Mr. Shea, there's Ms. Harker,
public observers.
there's Mr. Shea. Okay. All right, we're going to mute everybody but the parties and the lawyers. Let's call the case, Anthony.
All right, now calling State of Minnesota versus Jessica Harker. Court file numbers 19HACR 192768.
All right, this hearing is being conducted remotely today, and we are doing this remotely over the Zoom platform on the internet in order to minimize the need for in-person court hearings due to the risks associated with the ongoing COVID-19 pandemic. All of the parties and lawyers and the judge are appearing remotely via audio and video, and we have a number of observers. I will say before we get started that the court rules prohibit any recording of this hearing without a specific court order request and I have not received any in advance and according to the rules, and it also prohibits any screenshots to be taken during the hearing. So with that, let's note appearances from the state first.
Corey Monens on behalf of the state.
And on behalf of Ms. Harker.
Kevin Shea appearing on behalf of with Jessica Harker.
All right, and I see her here too. Thank you for kindly appreciate that. So this hearing was, I set it on in response to the application and proposed warrant submitted by the state alleging certain violations of Ms. Harker's conditions of release, specifically relating to a series of alleged email communications between Ms. Harker and the law clerk and others relating to her pending child custody case, I think is the best way to describe that case. I set it on for what we would normally call in the real world a walk-in hearing, but we're doing it by Zoom today. Mr. Shea, is there any objection to proceeding remotely today?
Nothing, Judge.
And Ms. Monens?
No, Your Honor.
So, one of the things that it wasn't mentioned in your applications, and I think I gleaned from my review of the materials, was that since the conditions of release were last revised, or since the condition was imposed about not emailing the court in the family custody case, and that all her communications would be directed through her attorney, I think since that time she discharged or that attorney withdrew. Can you confirm that, Mr. Shea?
Your Honor, that is, I think the attorney that withdrew in the family court file was Mr. Meyer's attorney. Ms. Harker has proceeded pro se during the bulk of that proceeding.
Okay, she does not have an attorney of record, in other words.
That is correct.
That's what I thought. And so that led me to think that we might need to rethink that, because from my reading of the emails, it was the law clerk that sent the first email directly to Ms. Harker. And obviously when we have pro se folks in court, especially conducting Zoom hearings, there's lots of emails between the parties and the court staff. And I know the condition of release originally said communications only through your lawyer, and I don't know if that ever got modified. So, Ms. Monens, if we could start with you today.
Thank you, Judge. And I actually think if the court looks at the language of the conditional release order, the only thing that mentions her attorney is actually in this case, and specific to the family law case, it says that email communication is prohibited, but she's not prohibited from filing anything into that case. The only thing that mentions an attorney is that she may communicate to the court and its employees through her attorney only on this case. So I do think we've known all along that Ms. Harker is representing herself in that family law case. And at the last conditional release violation hearing in August, the court reiterated this language and expressed to Ms. Harker that the only way she is supposed to communicate with the court in that case is through e-filing, because that was the basis for the last conditional release violation in August. Judge, I filed this request based on a series of 12 emails. All 12 of those emails occurred on Monday, October 26th, 2020. I do recognize that this started by Judge Offerman's law clerk sending the Zoom hearing notice to Ms. Harker. Certainly, I would not have requested a conditional release violation if it was simply one reply to that email or something of the sort. But this was a series of 12 emails that occurred after Ms. Harker actually started 2 new email chains that weren't even a part of that initial email from the law clerk. And the law clerk was a recipient on those new email chains. I anticipate that Mr. Shea is going to argue that Ms. Harker was trying to advocate for herself and her family law case. The Zoom hearing that was set to take place on October 27th did in fact take place. Ms. Harker did not appear via Zoom. So the state has concerns that she has been directed to handle her filings in a certain way in that case. And even if she had appeared and Judge Offerman might have been able to address these emails, then I might have reconsidered filing this warrant. But that did not happen because Ms. Harker did not appear. So to the extent that she wants to advocate for herself and her family law case, the proper way to do that is to appear on the record, make filings so that her concerns can be noted, but she did not take advantage of that, and instead these harassing emails occurring over 12 emails in separate chains in approximately a little over 2 hours on the morning of October 26th were provided to law enforcement. Judge, I know you're familiar with the conditions of release in this case, and an email of a similar nature to this one was the basis for a conditional release violation back in August. That was just one email, and bail was raised in the amount of $5,000. Ms. Harker continues to fail to abide by conditions of release, and the state would ask that an additional $10,000 be imposed as a consequence for this conditional release violation. Thank you.
Bail is not
Mr. Shea.
Your Honor, we would oppose any modification of this year's release conditions. This was an isolated incident while she's been on release, and frankly, to put this in a bit of context, it looks like this recent series of events occurred when Ms. Harker filed a motion in her family law case, I believe on October 22nd, requesting to appear via Zoom because she advised the court that she was under quarantine for COVID-19. It was shortly after that initial filing that she made that she was contacted by Judge Offerman's law clerk, given instructions as far as the Zoom call for that particular day. At some point, there was an inquiry made regarding whether or not a report from the assigned guardian ad litem had been filed, because Ms. Harker hadn't seen it. I think she was provided with a copy shortly thereafter. My understanding is that she was upset that there was references being made in the report to her having outstanding warrants on these new misdemeanor files that have been filed. That was the first time Ms. Harker had heard anything about that. Frankly, Judge, these misdemeanors filed by Campbell Knudsen Law Firm, the city attorneys for Burnsville and Lakeville, all deal with alleged incidents that occurred either a year ago or last spring that I believe have been addressed either formally or informally by this court in this case. Some of these incidents were occurring almost simultaneously with various arrest requests that the state has made in this case in the past. And on October 19th and 20th, the city attorney filed 8 separate complaint warrants, none of which contain Miss Harker's correct address as where she could be located. All made allegations that she couldn't be located and that a warrant was necessary. That was Miss Harker's first knowledge of these warrants.